All right, all right, all right. Good evening, everybody. Hope everybody is doing pretty good. Before I begin, I need to know on a scale of 1 to 10, how good can you hear me? Let me check this chat right quick. All right. Give y'all some time to come on, get online. I think I want to trade. On a scale of 1 to 10, how good can y'all hear me? If anybody's watching, how good can you hear me? Let's see. 10. All right, cool. 10. All right, all right. Okay, y'all do me a favor, hit that like button for me. I would really appreciate it. The case was it Chicago versus Collins? I've already read the case and talked about it. It's essentially the right to travel case, but this video with this live is for me to basically substantiate what they're talking about in that case and what they're not talking about in the case. Well, it's more so to tell you what that they are talking about, but and it's based on my own personal research and stuff like that. But anyway, y'all gotta pardon me, y'all, because I am tired. I was cutting grass today, and I'm mentally exhausted. I came home, I took a bath after I cut grass, and I just half cleaned up the house. I just like, you know what? I'm just forget it. I don't even feel like it. So I'm a little tired right now, but I'm gonna go ahead and what the first thing that I want to talk about. I want to get into these comments. So give me a second. Let me go to YouTube. Because in this video, I want to ban. I'm going to ban him in this live. He's just wrong. The purpose of me even banning him is not so much is because he's wrong. It's because he's just a hater. That's all he is. He just hate. His comments. He doesn't expressly say it. He implicitly says it. I know you can't sense emotions from comments, but I read enough of his comments to reasonably conclude, in my opinion, that he's just a hater. So let's go to the let's go down here. Where are we at? Is this it? Is this dude right here, the black squirrel? I ain't gonna even say his name. All right, but I'm gonna read his comment. Not this comment, but it's another comment. I'm going to substantiate. I'm going to explain this case and just to tell y'all why he is wrong. All right. Where are we at? Right here. I think it's this case right here. No, it's not. Wait. No. I'm sorry. Let me go down. Right here. It's this comment right here. Right here. This is where he starts. I make this comment right here. I say, I really think this went over so many people's head. So I'm sharing it again, and then I post the case citation, and then I post the case. This is the case we're going to read right here. This is the case citation. I'll read that case citation once we start reading the case. So his comment, it's important to note that the above is in reference to a challenge to a city ordinance in which the city of Chicago wanted to require an annual license fee to anyone who operated a vehicle on public streets within the city. All right, let's go down. And someone says, meaning, he says, meaning that the ruling had nothing to do with states requiring a driver's license to drive on public roads. Notice that they're still using this term driver. Still using, I don't care how the legislature modifies this this definition from its original common law meaning. It still means that. I don't care if they do that. That's the whole purpose of them modifying the definition or amending or changing the definition, because they're trying to hide it. That's what they're doing. So this is what he says. All right. So I come in, I just say, shaking my head, it actually did implicitly. When I have time, which is now, I'm banning you. After you're banned, I'm going to show people why you are wrong. I can't ban them because it doesn't allow you to ban them. It just says hide user from channel. But I wanted y'all to see that comment. All right. So again, he's saying that the case that I'm about to read to y'all says it has nothing to do with the states requiring driver's license on public roads. All right. So we're going to go ahead and we're going to read the case. I've already read it, but we're going to read it again. I'm not going to read everything in it. I'm going to read the important parts of it. All right. Y'all can go and read the case for yourself. The case citation is 175 Illinois 445. It was decided in 1898. So right now, somebody has filed a bill, in other words, an injunction against the city of Chicago. All right. So in other words, the Supreme Court of Illinois is sitting in equity. That's what they're doing. They're sitting in equity. So in other words, somebody filed a bill in equity. All right. So the appealees, 373 in number, residents and taxpayers of the city of Chicago, suing in behalf of themselves and all others similarly situated. That means everybody else who this ordinance is affecting, filed a bill to enjoin, in other words, a bill in equity to enjoin, or in other words, to prohibit, to stop. In other words, it's an injunction. A bill to enjoin the city from enforcing an ordinance providing that all vehicles used upon the streets of the city, including those for private use, for pleasure, etc., should pay an annual license fee, in other words, a tax, and that any person using any vehicle without first having obtained a license therefore, or failing to have said vehicle properly tagged, I'm not, when they say tagged, I'm not sure if they're talking about a license plate or some sort of sticker or something like that. I'm not really sure. So that it would appear that the license had been paid, should, on conviction, be fined a sum of not less than 10 or more. Let me see, not less than 10 nor more than 50 for each offense. $50, whatever, $10, blah, blah, blah. All right, go down and read a little bit more. It will be seen from an examination of such ordinance that it imposes a license fee or tax on all vehicles used on the streets of Chicago, even those in private use and not let or for hire. I'm sorry, and not let for, what are they saying? I'm sorry, I'm a little dyslexic. Even those in private use and not for let or hire. Okay. All of the appealees are owners of bicycles, and many of them other wheeled vehicles propelled by horses. Pay attention. You see how they're saying a horse and carriage is a vehicle? Now I want y'all to keep in mind, okay, this is way before 18-wheelers, truck drivers. This is way before they existed. But that is irrelevant because the principle still applies today. Let me see. All of the appealees are owners of bicycles, and many of them of other wheeled vehicles propelled by horses. 300,000 bicycles and carriages in private use only, are affected by the ordinance. The appealees use their bicycles not for the purpose of traffic, which is a commercial term, or for carrying merchandise or passengers. Give me a second, I'll be right back. All right, y'all. So let me see. All right, the appealees use their bicycles not for the purpose of traffic or for carrying merchandise or passengers for hire upon the streets of Chicago, but solely for their private use and as a means of locomotion from place to place, not letting or hiring either said bicycles or wheeled vehicles to any person or persons whomsoever, and 300,000 other vehicles in the city of Chicago, all of which are subjected to the license tax imposed by the ordinance, are similarly used. So I want y'all to, they're pointing out the distinction between the privilege of using the public highways and the right of using the public highways for your own private business. Is for your own personal pleasure. They're pointing that out. They're distinguishing. They're drawing the distinction in this case. Let me go and check the comments right quick. SG got pulled over by a female officer for the first time ever a couple nights ago. She let me go with no citation after I explained why I didn't have tags. That was a first also. It's good to know. I'm glad you made it out safe too, man. Y'all hit that like button for me if y'all don't mind. I really appreciate it. Hit that like button. Okay. So like I said, right here, they're drawing the distinction. They're substantiating, they're explaining without explaining the distinction between using the public highways for your own private pleasure or business as opposed to using it for hire or what is it? I can't even think of the term right now. Anyway, y'all should get what I'm saying. If you don't, let me know, and then I'll try to explain it a little later in the video. I mean, in this live. Let me see. Okay. All the personal property of the appealees owned by them on May 1st, 1897, subject to the taxation, has been listed and assessed for taxation. And inasmuch as the law is uniform, it is reasonable to conclude that all other personal property, including the 300,000 other vehicles affected by the ordinance, has been similarly listed and assessed. That's a reasonable conclusion. All right. The bicycles owned by the appealees range in value from $500 to $1,500. That's a lot of money for a bicycle back in 1898. That's a lot. And so-called money anyway. And the value of the other wheeled vehicles from $25 to $5,000. And it is not denied by the answer that every day the appealees use one or more of their vehicles, and that inasmuch as they are confined during the working hours of the day very closely to their places of business, it is needful for their health and mental and bodily vigor that they take exercise in the streets, boulevards, and parks of the city, that many thousands of people in the city of Chicago are similarly situated, and that unless they submit to the to the exaction of the illegal ordinance. In other words, unlawful. I ain't gonna say it's unlawful. I think the ordinance is unlawfully being applied, being enforced against them. Exaction of the illegal ordinance, they will be debarred of the privilege of so using the streets, and will be greatly injured in their physical health and enjoyment. It is contended that the ordinance is void because the city has no power to require a license for private vehicles used on the streets of the city, nor to impose a tax by way of license. Give me a second, y'all. I'll be right back. It's definitely important. No, it's not. And I tell you, I'm gonna let you know. Go sit down. All right, y'all. Sorry about that. Let me read that over. It is contended that the ordinance is void because the city has no power to require, in other words, to tax private vehicles used on the streets of the city, nor to impose a tax by way of license. That a tax so imposed on vehicles on account of their different values would not be uniform, that great injury would result because of injury to health, because of injury to health and because of interference with the right of complainants to use the streets, and consequent injury to business by the prevention of free locomotion from place to place, and by citizens being harassed and arrested. They were doing this back then, y'all. So in other words, the city would pass these ordinances, and police officers, the corporate police officers, the revenue officers, when people did not have these license plates, I'm not going to call it a license, I'm going to say a tag, or if they did not pay the tax or something like that, they were harassed and arrested. This is over 100 years ago they was doing this. The bill prayed for an injunction perpetually enjoining the enforcement of the ordinance. Let's get down. Where we at? So somebody, who is this? Okay, so somebody for the appealees, essentially what they are arguing is, long story short, the ordinance is void because unreasonable and oppressive and violative of constitutional rights. That's what they're arguing. The ordinance is a tax, which is it is, and is invalid because it is not uniform and constitutes double taxation. That's also what they're arguing. All right. So let me get down where we at. Right now, this is the chancellor. They in equity, they don't call them judges, they call them chancellors. So right now, he is exercising discretion to see if he has the authority to issue the injunction against the city. That's what he's doing. I'm not going to read that. Y'all can go and read that. As a matter of fact, I would advise y'all to go and read that so you can understand why. What I'm going to focus on is the stuff that I highlighted in blue. All right. The streets and alleys of a city are held in trust by the municipality for the use of the public, for purposes of travel thereon, and as a means of access to and egress from buildings abutting thereon or lots adjacent thereto. The right to travel on and along the streets of a city belongs to the general public and does not belong to its denizens alone. The right to travel being in the general public everywhere, all persons have a right to pass along and use the streets and alleys of a city in all their parts, the full width and length thereof. The municipality, which is a mere trustee of the public and holds the streets and alleys in trust for that public, cannot deny the right of the public to use the streets and alleys. What they're telling you is use of the public highways is a right, so they can't tax you for using it, except under such and such. Well, let me rephrase that, because they can't tax you for using it at all. So I'm gonna hold off on explaining that. I'm gonna read the case some more, and then I'm gonna provide y'all with some commentary on it. The municipal, well, I already read that. Let me see. It cannot assume an exclusive ownership and then deny the rights of the beneficiary. And then deny the rights of the beneficiaries under their trust and arrogate to itself a power greater than that of a mere trustee, and prevent the use of the streets and alleys by individual members of the public. This is why sovereign people of Illinois created this court, to protect their private rights. They created that court in their constitution. That is why they created that court, because these idiots think they can do whatever they want to do. Y'all hit that like button for me if y'all don't mind. Hit that like button. All right. Let's see. Okay. The right of the public to use the streets is the right to use them for purposes of travel in the recognized methods in which the public highways of the state are used. Any method of travel may be adopted by individual members of the public. So when they say any method of travel, they mean horses, they mean bicycles, they mean walking, they mean motorcycles, they mean skateboards, they mean rollerblades, they mean hoverboards, whatever you want to call it. Horses, carriage, they mean any method of travel. All right. Any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion, or even an extraordinary method. So what this is saying here is truck drivers have a right to use the public highways, and they cannot be taxed for simply using the public highways. In other words, the state or the city cannot require them to have a license to use the public highways. All right? They can't do that. That's what they're saying. If it is not of itself calculated to prevent a reasonably safe use of the streets by others. If a right exists in the city council to impose a license fee by way of tax on every person using wheeled vehicles thereon, it may in like manner, pay attention to this, y'all, impose such license fee for such use of the streets in every other manner of locomotion or travel, and reach the man on horseback or the pedestrian walking along the same. So in other words, what they're saying is, if the city has a right to tax you just for using the public streets, then that means they can tax you for walking down the street. In other words, they can require you to have a license just for walking down public streets, and they can't do that. This case clearly says that they can't do that. All right. Any usual method of travel along the streets and alleys of a city cannot be declared a nuisance or nuance or whatever. The city council may regulate the use of the streets and alleys to the extent that it may require sidewalks exclusively reserved for use by pedestrians, and exclude certain character of loads, and regulate the width of tires on vehicles used on a certain character of pavements, and provide that the rate of speed shall be much less on certain streets than on others, and otherwise regulate the use of the streets, having in view solely the welfare and safety of the public. Now we're going to get into this driver's license thing. The city may also regulate certain occupations. So when they say the city may also regulate certain occupations, they're talking about occupations that are used on the public streets and highways, like truck drivers. But they didn't call them truck drivers back then. All right, they used other terms for it. All right. The city may also regulate certain occupations, such as a hackman. We're going to stop right there because we're going to Google what a hackman is. And I want y'all to see how all of it relates to somebody using the public highways as a place of business. Let's see. This is the only term for hackman that I can find. I was trying to find another one. But anyway. Let's see. Hackman. The driver of a hack or a taxi. Let's see what a hack is. A hack. Okay, and which sense of it is being used? A noun, a good cash. Hacks for the holidays, verb, past time, a person. Hired as a hack. So many I can't even, I wish I could find it. But so far, let me see. We're going to go to Hackman and we're going to go to Wikipedia. We ain't talking about Hackman. Pulling up Gene Hackman. I don't know what that is. Talk about no Gene Hackman. So far, Hackman. Okay, I think we got something right here. So let's see. Driver of a hack, a carriage, cab, or taxi. So in other words, they didn't. I'm of the opinion, based on reading this, they did not call them driver's license. They didn't call them that back then. I'm not sure what they call them, but they didn't call them that because they're not saying, and they're not even mentioning driver. They're not expressly mentioning it in the case at all. So let me see what a hack is. Hopefully we can get some on here that are substantiated. Driver of a hack, etymology. This is a long. Tool chopping, hacking. So it's the best way to know what they're talking about in this particular case would be to try to find a case on it. Okay. This might be one. Drivers, so Hackman, they're talking about let me go back and read this case. Read some more. Okay. The city may also regulate certain occupations, okay, such as hackman. All right, so I got one. One was the like a driver of a taxi cab or carriage or something like that. So maybe it would be something like this: hack, a horse for hire. Okay, hacks, especially one which is old and tired. They stupid. That's funny. Okay, that's one of them. But notice that they're talking about business. The driver of a hack, a carriage, cab, or taxi. Okay, so that makes sense. Now I want y'all to keep in mind they did not have actual physical cars back then, all right? But they still called these people operators and drivers and stuff like that, all right? And I'm gonna show you. I'm gonna show y'all that. So we got hackman out of the way. So it's like it's either a horse for hire or a taxi cab driver or something like that. Even though back then they didn't have taxi cabs, so they must have had like a horse and carriage, and they would probably call the horse and carriage a taxi or something like that. I'm just guessing. I don't know. All right. Hackman was a little hard for me to find, but I can see why they're saying certain occupations. And notice that they say certain occupations, not every occupation. Certain occupations. All right. The city may also regulate certain occupations, such as hackman, Drayman, let's see what drayman is. I think it's a drayman. All right, drayman. Let's see. Drayman meaning etymology. Let's see what we can find on here. We're going to go on Wikipedia too. All right, a drayman is, I think this has something to do with some beer or something like that. I'm not really sure, but I think that's what it is. The earliest known use of the noun drayman is in the late 1500s. Meaning and use. Let's see what we ain't got nothing on here. All right, we got to go find something else. Okay, so let's see right here. Drayman. Okay. A drayman, and I don't use Wikipedia a lot, but I do think sometimes they have some valuable information on it. Let me see. This article is about the driver. Oh, okay. A driver, y'all. Anyway, a drayman was historically the driver of a dray, and they got some pictures on here too of a driver of a dray. A dray, okay. So in other words, a drayman is the driver of a dray, and a dray is this. This is a dray. See this right here? This is a dray. So in other words, this is the equivalent to back then. You can reasonably conclude that this is the equivalent to an 18-wheeler back then. All right, they're using the roads for business. But we're gonna go on. We're gonna go on a little bit more. All right. A drayman was historically the driver of a dray, a low flatbed wagon without sides, pulled generally by horses or mules that were used to transport all kinds of goods. Transport goods. These are commercial terms. All right, modern use. Okay. The word drayman is used in U.S. ports as the over-the-road highway truck drivers. Look at this. Who delivers containers to and from the port. Look at this, y'all. Look at this. Is this making sense for y'all? Because this sure makes sense to me. It makes sense to me. This is why you got to go and research what they talking about. Yeah, you drive the horses. Okay, SG saying hack is short for hackney carriage. Okay, horse and buggy, essentially. Okay. Not for hire private carriage. Y'all hit that like button for me if y'all don't mind. A dray would be like a flatbed trailer. Oh, okay. Okay, so like flatbed then, SG. So like I have a class A CDL. And we call it like if you do flatbed, we just call it flatbed. And what you do is sometimes they haul huge metal plates. Sometimes they haul these steel coils. Sometimes they haul wood on it and they strap it down. Or sometimes they chain it down with actual chains and stuff like that. Okay, that makes perfect sense to me. That makes perfect sense to me. So today, can we reasonably conclude, based on what we just read, that not a hackman, because I'm not really, because a hackman is this wasn't mentioned in regards to a hackman, all right, but a drayman. So can we reasonably conclude, based on what we know, that a drayman back then was essentially a truck driver, like an 18-wheeler truck driver, a CDL driver of today? Can we reasonably conclude that, based on what we know? Let's see. I'm going to go back. I'm going to read this again. The word drayman is used in U.S. ports as the over-the-road highway truck drivers who delivers containers to and from the port. So in other words, what they're saying is a drayman is essentially, a drayman back then is essentially a truck driver now. That's what they're saying. That's exactly what they're saying. All right. So right here, this is a dray. This would be a driver right here, this man up here. All right. This would be the dray back here, the flatbed thing or whatever. And this would be the horses or whatever. This is the horsepower, the motor, or so to speak, if that makes sense. Is this making sense for y'all? Because this makes so much sense to me. It makes so much sense to me. So much sense to me. So let's go here. The drayage company and draymen provide carriage from or to a port or railway ramp. The items hauled, these are truck driving terms, are either ocean or rail containers, okay? The contents are either cross-docked or outbound long-hauled carriage, or the container is drayed to the receiver who unloads it. This is truck driving, y'all. When I was driving over the road, I would get a load. I would write down all of my paper. I would write down, my load number. I would do my I would schedule everything from like when I was going to start driving, when I was going to stop driving, when I was going to take a break, how long it was going to take me to get there. Then when I got there, I would check into the office, to the receiving office. I would go in with my paperwork, come out. I would go around to a dock and back my truck up to a dock, and it was unloaded. All right. The drayman then hauls the empty back to the ocean port this is truck driving, y'all. That's exactly what this is. That's truck driving. Y'all hit that like button for me if y'all don't mind. All right. So we got that out of the way. Drayman. All right. So hackman, drayman, expressman, and the like. And the like is extremely broad to the extent that it is within any of these, to the extent that it is very similar to these other occupations, is what I'm trying to say, and the like. So let's say, even though we don't see the term truck driver in here, can we reasonably conclude that truck driver falls today, like a commercial truck driver? Can we reasonably conclude that a truck driver of today falls within this definition or within this meaning and the like, based on the research that we have concluded about what a drayman is, a hackman is? Well, I'm not going to say hackman, but a drayman. We're going to say drayman, because a drayman, it's almost identical, if not identical, with what a truck driver was today. All right. So the other term is expressman. So let's see what an expressman is. All right. I'm thinking what an expressman is somebody like UPS, FedEx, Amazon. Who else delivers? Courier Express or something like that. That's what I'm thinking an expressman is. I could be wrong. We're gonna see. Expressman. Let's see. Expressman is a person who collects and delivers goods. Okay, then I would be right if that's what an expressman is. Let me see if Wikipedia has the definition. Expressman. All right, let's see. An expressman. refers to anyone who has the duty of packing, managing, and ensuring the delivery of any cargo. During the late 19th and early 20th centuries, an expressman was someone whose responsibility it was to ensure the safe delivery of gold or currency being shipped by railroad, and which was secured in the express car. Okay, so it can be used as somebody on the railroad, I'm guessing, in that term too. But still, I want y'all to see how this is relating to commerce, to business, to transporting something. You're being paid to do it. You're under a contract to do it. You're employed to do it. All right. Sounds like intermodal. Intermodal, yeah, you can say that. It sounds like intermodal too, yeah. Okay. Now that we got that out of the way, so let me start back over. The city may also regulate certain occupations. Y'all pay attention to that. Occupations, such as hackmen, draymen, expressmen, and the like. For such regulation is of a police character, having reference to the general welfare as a means of preventing improper exactions and extortions. And for the same reason, a license may be exacted for such vehicles used in the transportation of goods and merchandise, or of passengers, or for other purposes of traffic. But such license is an occupation license. What occupation are we talking about? A hackman, a drayman, expressman, and the like. People who are using it for business purposes and not for their own pleasure. People who are trying to use it to make money. But such license is an occupation license. But such license is an occupation license and not one for the use of the streets. They cannot tax you, in other words, require you to have a license for using the public streets, except if you are a hackman, a drayman, an expressman, and the like. Anything like what they just said. The license in the latter named case is designed to operate upon those who hold themselves out as common carriers. And a license may be exacted from such a proper exercise of police power. But no reason exists why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business, meaning in your own business, like your own job, your own occupation, or for their own pleasure as a means of locomotion. This case, it does not expressly say it. It implicitly says that they cannot require you to have today a driver's license if you are not using the roads for a place of business, such as in the manner of a hackman back then. So today we're going to say a taxi driver. We're going to say an Uber driver. We're going to say a truck driver. We're going to say an omnibus driver. That's what we're going to say, even though a horse and carriage is considered a bus back then in like the early 19 or 1600. It was something like it might be a little further than that, but they used to call horses and carriages omnibuses. And it's literally a horse and carriage, but they calling it a bus because it falls within the meaning of what the legislature considered a bus. All right. So we got that out of the way. I might read that again. You go to the chat. Hit that like button for me if y'all don't mind. Hit that like button for me. Let's go back to it. The license in the latter named case is designed to operate upon those who hold themselves out as common carriers, and a license may be exacted from such as a proper exercise of police power. But no reason exists why it should be applied to the owners of private vehicles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. And here are all the cases. So in other words, all of these cases right here that I just highlighted right here, he has condensed, the chancellor in this case has condensed basically a summary of the law right up here for you based on all these cases right here. That's what he just did. Anything which cannot be enjoyed without legal authority would be a mere privilege, which is generally evidenced by a license. Pay attention to this, y'all. The use of the public streets of a city is not a privilege, but a right. This is over 125 years ago. The use of the public streets of a city is not a privilege, but a right. They cannot tax you. In other words, require that you have an occupation license that they're calling a driver's license prior to you using the streets, because it's a right to use it. So what they're saying is the tax that is being enforced is not for using the streets. It's an occupation license. That's what they're saying. A truck driver a driver of a truck is an occupation. A driver of a dray is an occupation. A driver of a hackman is an occupation. An expressman, a driver of some whatever you want to call it, is an occupation. That's what they're saying without saying it. Yep, Lyft drivers also. That's why you can use a truck of duty. I'm sorry, that's why you can't. Did you mean can't or can't? Oh, you must be a truck driver. I see what you're talking about. He says that's why you can't use a truck of, let me see. Oh, okay, I get it now. You're right. You're saying that's why you can use a truck off duty for personal conveyance if not hauling freight. Okay, yeah, you're right. I used to do that a lot. You're right. You're right. But look, based off what I'm saying in this video, I just want to know, is this making sense for y'all? That's what I want to know. Because this case clearly tells you that they cannot tax you. They cannot enforce an occupation on you that you are not engaged in. Because a driver is an occupation. So they're saying you have some sort of occupation in using the public highways and the public streets. That's why they want you to have a driver's license. They're taxing you because a license is a tax. And they're taxing you. They're unlawfully enforcing this ordinance on you. So in other words, what I mean is they are enforcing this statute beyond the scope in which the legislature authorized them to enforce this ordinance. That's what they're doing. They are violating due process when they do that, because you cannot do that. This statute, this ordinance does not lawfully apply to me. I'm not saying that the legislature and the city council enacting this ordinance did it in an unlawful manner, or in fact that the ordinance or statute is unlawful. I'm not saying or unconstitutional. I'm not saying that. What I'm saying is it does not lawfully apply to me because I do not fall within the definition of the term driver. And if you don't fall within the definition of driver, then the ordinance and the statute does not lawfully apply to you. If your private conveyance does not fall within the legal definition for a vehicle or motor vehicle, then the statute does not lawfully apply to you. So what they hid the commercial aspect of what's really going on. They omitted them from the statutes and the ordinances. They're hiding it. from the ordinance and statutes. That is what they're doing. So they don't put for hire in there anymore. They don't put for all or let for hire or for or use for all commercial purposes or anything like that in the statutes and the ordinances. They took it out. I don't care if they took it out because the term driver still means back then what it means now. I don't care if they modified the statute or the ordinance. I don't care. It still means the same exact thing. They're hiding it. Us dumb truck drivers getting educated on the law. You stupid, is she? Oh, let me see. Let me see. All right. I think I'll read a little bit more. I'll read a little bit more. The use of the public streets of a city is not a privilege, but a right. All right. It is therefore conclusive that the general requirements of a license for the pursuit of any business that is dangerous to the public can only be justified as an exercise of the power of taxation or the requirement of a compensation for the enjoyment of a privilege or franchise. In Cooley on taxation, it is said, a license is a privilege granted by the state, usually on payment of a valuable consideration, though it is not essential. To constitute a privilege, the grant must confer authority to do something which without the grant would be illegal. For if what is to be done under the license is open to everyone without it, the grant would be merely idle and nullatory, conferring no privilege whatever. A license, therefore implying a privilege, cannot possibly exist with reference to something to which is a right, free and open to all, as is the right of the citizen to ride and drive over the streets of the city without charge, without tax, and without toll, provided he does so in a reasonable manner. This is equity that we're talking about here. So remember when I don't know if y'all saw that post. Let me go and show y'all what I'm talking about. And then I'm gonna ban this idiot. Matter of fact, let me just go on and get him off here now. Go on get this hate off here right now. All right, so let me see. Make sure I got that hate off here, man, because he just be hating. Ain't got time for all that. All right, bet. All right, so let me go back to the community section on here. He just be hating for no reason, just hating. Right here, this right here. Even if there were no statutes, everyone would still be required to use the public highways, local streets, and interstate in a reasonably safe manner. Some of the old cases that I read appear to predate the adoption of the legislature of these principles. Equity demands that you act reasonably pretty much everywhere you go and in all of your dealings. Equity demands that. That's equity. He had a question about that, but I don't answer his questions. I ignore him, and I just blocked him, so whatever. I had to get him up out of here. Where is it at? Within a reasonable manner. Okay. That such a right exists in Chicago is recognized in Smith versus McDowell, 148, Illinois 51, where it was said relative to the streets of a city. The grant of power is the grant of power in this particular is to be construed in view of the purposes for which the municipality is invested with the control of its streets, alleys, and public grounds. The municipality, in respects of the streets, is a trustee for the general public and holds them for the use to which they are dedicated. The fundamental idea of a street is not only that it is public, but that it is public in all its parts for free and unobstructed passage thereon by all persons desiring to use it. They can't, y'all, they know about this stuff, y'all. I'm not going to tell y'all this. So if you, today, I'm going to tell you this right now. If you try to get them to adjudicate this on the public record right now today, they are not going to do that. You're wasting your time. They're not going to give you any meaningful and proper disposition of your argument. They're not going to do that. This is extremely controversial. This goes against, this would seriously, in my opinion, injure the integrity of probably the entire system, if not the judiciary, then the legislature, or all three, probably all of them. It would seriously expose what is actually going on. Because people, once they start questioning this, and let's just say the government just comes right on out, or some so-called judge somewhere just comes right on out and say, you know what, you're absolutely right. You have a right to travel without a license, insurance, and all this, yada, yada, yada. And we're sorry for doing that. All hell gonna break loose. They're gonna lose so much so-called money. This is probably a $5, maybe $10 trillion secret that they don't want to tell people. They're not going to tell you that. You're wasting your time. They're not going to tell you that. I'm not saying don't use the argument, because I've used this man's arguments, Carl Miller. I've used his right to travel arguments. I've used them 3 times. It worked twice. It didn't work 3 times for me. The first 2 times it worked, I was in the same city. And the 3rd time it didn't work, I was in another city when it didn't work. All right. So this is what they'll do, y'all. They'll say, like in a case, this was in circuit court. I had got a traffic ticket from a state trooper or something like that. And so I took it to trial, argued my case, blah, 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 this, blah, 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 that. And I used the right to travel argument. And so the judge, so-called judge anyway, he still adjudicated me guilty, all right? But he never issued a warrant. This was probably almost 10 years ago, and I never paid that traffic ticket. I still haven't paid it. And he never issued a warrant for it. You'll see something like that on the public record, where it makes it look like, okay, well, they adjudicated you guilty. It will kind of make it look like the so-called judge just forgot to issue a writ of arrest for you because you didn't pay the ticket or something like that. They'll make it look like that, when in fact is, I'm of the opinion that he didn't forget. He did that on purpose because of the argument that I made. He didn't tell me I was wrong either in none of my arguments. He didn't even consider the argument. He didn't cite any authority as to why he was ruling the way that he just ruled against me. That's what they do. That's what they're going to do. They're not going to tell you if you're wrong. What they might, if they do tell you you're wrong, they're gonna misquote some cases. They're gonna omit some facts, something like that. That's what they're gonna do. That's what they're gonna do. It's there, but under Title 49 United States Code, state laws are modeled after acts of Congress. Yep, they are. They are. Look at Section 300101 under the Title 41 and read the purpose. Yeah, I already know what the purpose is. I know exactly what you're talking about. They're hiding it, though, because they don't want people to know it. They're hiding it. You're right. I already know. Also, not for public use, private carriers, taxi drivers are considered chauffeur license, something like that. This is the reason why they're taxing people for doing this, y'all. All right. Let's say that people, let's say the city is fixing up these streets or whatever, and but there are a lot of people who are using the streets as a place of business. All right. So the people that are using the streets as a place of business, the city knew about these people using the streets as a place of business, but the city never did anything about it. They just waited, they was like, what, it's fine, They tacitly authorized it. They implicitly authorized it. All right. So now that the people, they've been using these streets, let's say they did it for like a year, 2, 3 years, something like that. And now the city wants to just finally stop these people from using the streets, the public highways, as a place of business. All right. And so the people who the city is trying to stop from doing that, the people, but they file a bill in equity against the city to enjoin them, to stop them from doing that due to long acquiescence. You slept on your rights. You can't do that. Equality under the law is mandatory. If the city sleeps on their rights, it's a wrap for them. If you sleep on your rights, it's a wrap for you. It's over with. Don't sleep on your rights. That's why they're doing that. Well, that's one reason why they're doing that. The other reason is they are unlawfully enforcing these ordinances and these statutes on people who do not come within the meaning of these ordinances and statutes, if that makes sense. They are enforcing these statutes beyond the scope in which the legislature intended them to be enforced. That's what they're doing. And they're hiding it. They took out for hire, any commercial they just took all of that out of the ordinances. That's what they did. Now, the reason why y'all need to go and read these old cases, because these old cases will just blow your mind away. So what I'm going to do right now, I'm going to read y'all this old case right here. This is the case Davis versus Petronovich, or whatever you want to call it. This is the case that a lot of people like to quote for the legal term driver, like right here. Let me see if I can find it. Driver, one employed in conducting, right here. All right, this one ain't gonna work. This might work right here. Nope, that ain't it. And y'all got to be careful. These words, man, they'll get you, boy. They will get you right here. Okay, so here's one right here. One employed in conducting or operating a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle. Look at this. A bicycle, tricycle, or motor car through not a street. I'm guessing this meant though not a street railroad car. A person actually doing driving, whether employed by owner to drive or driving his own vehicle. They'll get you right there. That's very tricky. They'll get you with that. Won't get me though, because I know what it means. So let me see. Let me go to case text and let me see if I can find, what does this M stand for? I think this stands for Maine or something like that. I don't know. We're going to see. If not, let me see if I can. Okay, here it is right here. I don't have to do that. Okay. So here it is right here. I think this is the. Okay, yeah. So here it is right here. Right here. Driver, one employed in conducting or operating a coach, carriage, wagon, or other vehicle with horses. Note that they're calling it a vehicle, mules or other animals, or a bicycle, tricycle, or motor car, though not a street railroad car. All right, so here's the case right here. Boom, right? That's the case I'm about to read right there. Now, I've read this case. This citation is not in this case that I'm about to read. It's not expressly mentioned in that case. It is implicitly mentioned in the case. And since it is implicitly mentioned in the case, then you can reasonably conclude and argue, and you would be right, that a driver is one employed in conducting a coach, wagon, blah, blah, blah. If you can reasonably conclude that this citation is implicitly mentioned in the case, then it means the same thing as if it was expressly mentioned in the case. Let's see. Is this what? I don't think this was issue was talking about. But anyway, I'm gonna go and read this case. All right, this is what they're doing. All right. Let me see. I think this is a bill in equity. So the Alabama Supreme Court is sitting in equity. This is an Alabama Supreme Court case. So they appealed it from the Chancery Court of Mobile. Now, I've been to Mobile. All right. They don't have this court no more. It's gone. All right. The name of it is gone. It's called a circuit court now. So in other words, the circuit court now is a court of general jurisdiction. Since it's a court of general jurisdiction, it hears cases at law, in equity, in admiralty, and maritime. It's a court of general jurisdiction. It is a court that was created by the Constitution and the sovereign people of Alabama. All right, so let's get down to this. The mayor and general counsel of the city of Mobile on March 16, 1896, adopted a general license ordinance levying a license tax against all trades and occupations carried on in said city, and included therein a license tax on bicycles. Okay. The complainant owned and used a bicycle solely and exclusively for his pleasure and convenience, and his bicycle was not used in any way for the transportation of goods or merchandise, and was not kept for hire at any place in the city of Mobile. Because if his bicycle was, guess what his bicycle would then be, y'all? It would be a vehicle, despite the fact that it's a bicycle. Go to this chat, see what's going on. She said Illinois is a police state. Y'all hit that like button for me if y'all don't mind. Let's go down. All right. So somebody for the appellant. The undisputed facts are that the bicycle owned by the appellant was not used in the transportation of goods and merchandise or kept for hire. The ordinance levying a license tax thereon was unauthorized, null and void. Power to license, tax, and regulate horse, railroads, hackney, carriage, etc., do not extend to the taxation of private vehicles used by a merchant or manufacturer. These are some cases. I'm going to have to go and read these. These look like some pretty good cases. The bicycle owned by the appellant does not belong to the class of vehicles upon which the city of Mobile had authority to levy a tax. That is what we're saying when we're arguing about these driver's licenses. We're saying that this ordinance does not lawfully apply to us. We're not saying that the ordinance is unlawful, or in other words, was illegally enacted. We're saying it does not lawfully apply to us. So where are we at? Pending suit. Where are we at? I'm trying to get to the chancellor because he's gonna. I think this might be it right here. Is this it? I think this is it right here. I'm trying to, give me a second. I'm trying to find it. I don't want to go too far. I think, I'm not even sure where does it start at. Where does it start? It might be way up. Okay, so it's going to be up here then. I'm guessing it's going to start about right here. So I'm going to start about right here. All right. The fact of the pendency of another suit by one Ralston against the defendant in this case in the same court with this suit and in reference to the same subject matter is not well taken. It was admitted on the trial of this case that the case of Ralston was instituted in Mobile Chancery Court. Notice that they don't capitalize the C in Chancery or court. On the 24th of March, 1896, that it was substantially the same in object and almost identical in the language with that of Davis versus Pigeonot's tax collector, this case, okay, and that it was brought in behalf of all parties in interest by Hugh Ralston, but was amended on the hearing so as to be only on his own account, and that the said Ralston bill was answered, evidence taken, and case submitted and argued on the pleadings and testimony at the same time with the Davis case. What disposition, if any, has been made of the Ralston case, whether or not it has been decided, is not shown, nor is it shown that said cause was submitted. So what are they talking about? I don't want to read all of it. I just want to get to the actual part of the case. I don't want to make this live too long. I don't know where is this thing starting at. I read this case and I forgot where it started at. I don't think that's it, because it normally, who issued this? It's for appellant Rich Hamilton. 1, 2, 3, 4. This got to be somebody for somebody else. So where's I can't even find it, y'all. Where is it at? They ain't even. It's confusing me. I'm sorry, y'all. This is confusing me. I'm trying to get to the chancellor who issued the opinion. Okay, so this is the appellant. He's arguing his case. Appellant. Where's the appellees? I'm trying to get to the part where it just sums it up. So I don't want to read all of it. Let me see, that a bicycle comes properly within the definition of a carriage or vehicle. We apprehend can no longer admit of dispute. A vehicle is defined to be any carriage moving on land, either on wheels or runners. A conveyance, that which is used as an instrument of conveyance, transmission, or communication. And a carriage is the same lexicon is defined, that which is used for carrying or transporting, especially on or over a solid surface, a wheeled vehicle for conveyance of persons. Damn it. So where's the damn? You know what? Because I don't want to make this too long. I can't even find it, y'all. Damn it. Do I need to make it smaller or something? Too big? What the hell going on? They normally tell you who issued the opinion, and then it goes on, because I don't want to read all this other stuff. Man, I'm sorry, y'all. This is just getting out of hand now. I'm sorry. So I can't even find it. I did read this case, though. Well, I'll just read y'all this summary right here. So basically, this is the summary. Long story short, that the bicycle was his private carriage used alone for the purposes of pleasure and not for the transportation of goods and merchandise. So in other words, this case essentially tried to tax this kid's bicycle, whoever it was, somebody's bicycle, and they tried to say that it was a vehicle and it was used within the manner as mentioned in the statute, in order for it to come within the meaning of the statute so that it can be a vehicle, if that makes sense. That's essentially what they're saying. So he filed a bill to enjoin them from doing that, because he said that this ordinance doesn't lawfully apply to me, because I use this bicycle for private purposes, no business purposes at all whatsoever, blah, blah, blah. That's essentially what happened. I wish I could find where it starts and just read it to y'all. But if y'all want to read the case, let me give you the case citation. I'm sorry, y'all. We just went through all that for nothing. Where we at? This is the case citation right here. Right there in all blue. That's the case citation. Employed. We know what employed signifies being under the contract or orders to do something. Let me go down here. Is it in here? It's probably in here. Let me go down here and see. Right here. So this is driver. Then I posted the term employed under here. Right here. The word employed is defined as follows: employed, performing work under an employer-employee relationship. All right. Term signifies both the act of doing a thing and the being under contract or orders to do so. To give employment to have employment. Employed, being engaged in rendering services or being under contract for the rendition of services. Yada, 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 blah, blah, blah. That's what they're saying with a driver's license. That's what they're saying. You're not crazy. Carl Miller is not crazy. Carl Miller is right. He's right when he tells you that there's this distinction between driving and traveling on the public highways. He's right, and the only reason why he's saying that is because the judiciary or the chancellors are saying it, which is the same reason why I'm saying it, because that's what they're saying. They're saying there's a distinction between the two. One is a privilege and the other one is a right. They're not saying that both of them can't be regulated. They're saying they can be regulated, but you cannot tax the right. You can only tax the privilege. That's what they're saying. In other words, you can only require people who are using the public highways for a certain occupation, or so to speak, such as a driver. That's what they're saying. All right. You won't. They're hiding this stuff, man. I don't know why. Why? I take that back. I do know why. They're hiding it. Why don't you use the current edition of Black's Law Dictionary? Many legal terms and laws have changed throughout the years. That's why dictionaries are updated. I agree, but it's still gonna mean the same thing. Let me. All right, I'm gonna go and pull up. Let's see if it's in the 8th edition. I have the 5th edition too. Damn, I took my flash drive out. Hold on, y'all. I took the damn. Did I take it out? Yeah, I did. Give me a second, y'all. It's still gonna mean the same thing. Like when people, let me see. Let me go on here. Give me a second, y'all. Let me go on this right quick, because there's a guy on here. On where we at? Call itself Black Prince or whatever. I think it's on a video. Right here, I think it's on this video. I don't even. There were comments about his Carl Miller's name or what, saying that's not his real name. How you gonna tell this man what his name is? If this man lawfully changed his name to Carl Miller, that is his name. I don't care what his legal name was, because you can change your name whenever you want without government intervention. They can't tell you when, and you, man, y'all people who come on this channel, y'all don't know what y'all talking about. It'd be a lot of people on this channel that don't know what they're talking about. People come on here, they insult me or whatever, yada, yada, yada. I don't care about none of that stuff. It doesn't bother me, because I still, believe it or not, I have to approve a lot of comments that are on this channel. And even the comments that are directed at me insulting me, I still approve the comments. I don't even respond to them because I don't care. It doesn't bother me. Let me go back. I didn't even know this had that many comments on it. I think it would be, I think it's on this one right here. So yeah, this guy right here, Black Prince, whatever you want to call him. So he wants you to believe this right here. That depends on whether or not the right you are alleging has been violated actually exists. For example, if you try to argue in court that your right to travel is violated by the requirements to possess a valid driver's license and to register your automobile, you will lose. That particular claim has been rejected by the courts at the state and federal level for over 100 years. I just showed y'all the case right here where he's lying. He doesn't know what he's talking about. He does not know what he's talking about. Anyway, this is the case right here. Let me get off this. Where we at? Right here. He says that's been rejected for over 100 years. No, it hasn't. You don't know what you're talking about. You don't know what you're talking about. Just don't know. Let me see. He said, I don't know, he was talking to me about something. Where we at? So I get the, I said, no, it had. I'm not going to argue with this guy all the way. We're not doing that. Let me see. Well, he cites this memorandum of law. This is what he cites. It's long memorandum or whatever, but sometimes you got to do that to get your point across or whatever. So I'm gonna read some of this. Let me see. The Supreme Court ruled over 100 years ago that a state has the legislative authority to enact laws regulating the use of its roads for public safety and order, including the licensing of drivers and registration of vehicles, and that this authority applies to all users of the state's roads. That is wrong. It does not. This is right. They have the authority to issue, they have the authority to require drivers of vehicles. Yeah, they do. Because I know what a driver is and I know what a vehicle is. A motor vehicle. I know what that is. Yeah, they have a right to do that. I'm not saying they don't have a right to do that. I'm saying that this statute does not lawfully apply to me. Because we've already established that there's a distinction between the two on the public highways. We've already established that the use of the public highways is a right. So they cannot tax you. In other words, they cannot require you to have a license to use the public highways. They can't do that because it's a right. So what can they tax? What can they require that you have? Let's go and see. Let's just go back and see, even though I already read this. I already read it. The city may also regulate certain occupations, such as hackmen, draymen, which is today is called truck drivers, expressmen, and the like, for such regulation is of a police character, having reference to the general welfare as a means of preventing improper exactions and extortions. And for the same reasons, a license may be exacted for vehicles used in the transportation of goods like truck drivers and merchandise, or of passengers like Ubers, or for other purposes of traffic, which is a commercial term. I don't care if the legislature modified in their statute the term traffic. It still means the same thing as it meant 100 years ago. But such license is an occupation license and not one for the use of the streets. The reason why is because you have a right to use the public streets and highways. Not just you, everybody. That includes corporations. That includes truck drivers. They have a right to use it. Okay? But they cannot use it for business purposes. In other words, a driver is an occupation. It's a job. He's getting paid to do that. He's employed. That's why they can tax him, meaning they can require that he have a license. It's not to use the streets. It's for an occupation because he is a driver. But anyway. All right. So let me see. And that this authority applies to all users of a state's road. No, it doesn't. In doing so, the court wrote that the enacting of those laws, which are not laws, statutes are not laws, because if statutes were laws, then they would apply outside of their corporate territorial jurisdiction, and they do not. They're not laws. As a matter of fact, if there were no statutes, there would still be law. You can sue anybody without a statute. You can appeal a case without a statute. You can get an injunction without a statute. You can change your name without a statute. You can sell property without a statute. You can file lawsuits without a statute. You can bring criminal charges without a statute. You still can do all of these things. Anyway, but an exercise of the police power uniformly recognized as belonging to the states and essential to the preservation of the health, safety, and comfort of their citizens, the U.S. Supreme Court has never reversed the position it took on the subject of Hendrick versus Maryland. Let me see what he's talking about. We agree that the states have a vital interest in ensuring that only those qualified to do so are permitted to operate motor vehicles. Notice that they're talking about operate motor. These are commercial terms. That these vehicles are fit for safe operation, and hence that licensing, registration, and vehicle inspection requirements are being observed. Automobile licenses are issued periodically. I know what an automobile is. Automobile is a vehicle to the extent that it is used within the manner required by the statute. I don't care if you call it look, man, a horse and carriage is a vehicle if it's used in the manner of that statute or ordinance. A dog is a vehicle. A cat is a vehicle. A horse is a vehicle. Skates is a vehicle. Rollerblades is a vehicle. A motorcycle is a vehicle. Is this making sense for y'all? If you're using it in the manner as required by the statutes, despite the fact that you're using a horse and carriage, it doesn't matter. They're going to say it's a vehicle because you're using it for a purpose, like business purposes or something like that. That's what they're saying. You can't pull this on me. You're not qualified for this. Now he hasn't. This is his warning. I'm not gonna, ban him from the channel. This is his warning. If he does it again, he's gonna get banned from the channel. But I'm gonna read this some more. Automobile licenses are issued periodically to evidence that the drivers, holding them are sufficiently familiar with the rules of the road and are physically qualified to operate a motor vehicle. I agree with this because I know what these words mean. The registration requirement, they cannot, I repeat, they cannot force you to register private property. Why are you registering private? If you register anything you register in the public, generally speaking, becomes public property, despite the fact that you think you own it. You think you own your car. You have public plates on your car. On your so-called car. You have a certificate of title. A certificate of title is not legal title. They stole your car, essentially. They're saying that it's yours. The state is saying that your car is theirs. And since it's theirs, they're going to put public plates on it. And since they're putting public plates on it, you're required to have a driver's license because you are performing a public service, because all public services belongs to the public. They're not going to tell you this. Why would they? Y'all, are you crazy if you think these people are going to tell you this? You out of your mind if you think that they going to tell you this. Give me a second, y'all. I'll be right back. Give me a second. Sorry about that, y'all. I can pull up so many cases. Let me show y'all this, man. Let me just do this. I gotta do this because people just they think I just be making stuff up. You got a certificate of title. First, let's see what legal title is. All right. Let's see. All right. Let's see. Let's see if we're gonna get it on here. No, they ain't gonna do it on here. So let's go back. Well, we'll just go to legal title. All right. Legal title. Absolute ownership of real property that is enforceable in a court of law, which is a common law court. Legal title to real property is evidenced by a deed that is recorded in the public records in the county, blah, blah, blah. All right, so generally speaking, legal title is absolute ownership. It is prima facie, you own it. It's yours. Nobody else has it. All right. The court further held that the certificate of title is not title itself, but only evidence of title. A certificate of title to an automobile is evidence of legal title. They're not saying that it's legal title. A certificate of title is not the same as legal title. This is from all over the country. You think you own your car. They give you a certificate of title. Guess who owns your car? The state. That's why they got state plates on it. That's why you have a VIN number and all that stuff on it. If you wanted to, because your car is yours and you have plenary power over all of your private property, you can create a VIN number and a private license plate for your car. You can do that. They don't want you to know that though, but you can. And do not try to do any of this unless you know how to cost these people money, because they're going to violate your rights. I'm telling you that right now. They're gonna call you a sovereign citizen and all that. That's what they're gonna do. I'm telling you that they're lying to you. And I'm not 99% sure, I'm 100% sure of that. A certificate of title is not the same as legal title. However, the transfer of a certificate of title alone is not sufficient to constitute a sale under Oklahoma law. Look at that. The certificate of title is not the same as legal title. The certificate of title is not itself proof of ownership or legal title to the vehicle. Look at this. Look at this. A person may have legal title in a vehicle even though he does not possess a certificate of title. Did y'all see that? Did y'all see that? A person may have legal absolute ownership in a vehicle even though he does not possess a certificate of title. You have the certificate of title, so who has the legal title? But we crazy now. I'm crazy. One, because they're for drivers. They are specifically for truck drivers, taxi drivers, Uber drive, people like that. That's who they're for. So what is going on, one, is um let me ask you this, one. Before I say this, on a scale of 1 to 10, how well do you think you can comprehend legalese before I say what I'm gonna say? When they say you have a right to travel, it's broad. Walking is traveling. Moving around in your house is traveling. You know, that's traveling. Going out to throw your trash away, that's traveling. Walking down the street, traveling. Riding a bicycle, riding a motorcycle, that's traveling. Using a skateboard, whatever, that's traveling. Those are different modes of travel. But go ahead, one more time. What are you on a scale of 1 to 10? How good can you comprehend legalese before I answer your question? Before I explain this to you. Let me see. It's not about what our rights is. It's more about the limits of government's power. They can regulate. I agree with that 100%, SG. I definitely agree with that. That's why a driver's license is. That's why we say a driver's license is dealing with commerce. That's why the term driver is commercial in nature. But they want to modify it and try to make it seem like that's not what it is. That's not what it is. That's not what it is. Well, he probably left. If he comes back, then I don't know if he left or not. But anyway, what was I gonna go? Right here. I'm just reading y'all these cases. Right here. This right here, man. A certificate of title is not itself proof of ownership or legal title to the vehicle. A person may have legal title in a vehicle even though he does not possess a certificate of title. The state has legal title, but the state doesn't have the certificate of title. You have the certificate of title. The state owns the car. Why would you register anything with the state? Unless unless you come within the meaning of a driver as specified in the statute, then yes, you register. A certificate of title is not conclusive evidence of ownership. Look at this, just 1985. It's all over the place. Look at it, just all over the place. They want y'all to think this, man. A certificate of title is not a warrant of ownership. A certificate of title is not conclusive proof of ownership. Look at this, just all over the place, y'all. All over the place. They want y'all to think this term driver is extremely old. It still means the same exact thing. They're still using the word vehicle. You know how old the term vehicle is? Old. Probably about as old as the term driver. But they're still using the term vehicle. The only thing is they just put the word motor in front of it. It's still a vehicle. Anything can be a vehicle if it's used for commercial purposes. Anything. Despite the fact that it is not a vehicle. Oh, I don't know. I probably did. I probably pronounced his name wrong. If I pronounced his name wrong, I apologize for that. All right. Let me see. So let me get back to this guy's comments or whatever. The registration requirement, and more pointedly, the related annual inspection requirement in Delaware are designed to keep dangerous automobiles off the road. Unquestionably, these provisions, properly administered, are essential elements in a highway safety program. Furthermore, we note that the state of Delaware requires a minimum amount of insurance coverage as a condition of automobile registration, implementing its legitimate interest in seeing to it that its citizens have protection when involved in motor vehicle accidents. Notice these are all commercial terms, man. I agree with all this. Notice that they're still using these commercial terms. I agree with all of this. Lower federal and state court, blah, blah, blah. Let's go here. Van Horn continues to assert that he possesses a constitutional and God-given right to travel on the roads of the state of Texas without having to comply with the laws of the state of Texas. I'm not sure what they mean by comply with the law. I got to see what they're talking about. These arguments derive from the so-called sovereign citizen movement and are legally frivolous. Okay, if they're frivolous, then why won't you cite the case law substantiating your argument? Don't just cite this because you're not giving him. I told y'all they're not going to give you any meaningful, proper disposition of your issues. That's why you don't argue this. You don't even bring it up in there. Anyway, these arguments derive from the so-called sovereign citizen movement and legally frivolous. Claimed sovereign citizens argue that although they reside in the United States, they are sovereign unto themselves and thus are not citizens of the United States, nor the state in which they reside. We don't say that. That's a lie. We don't say that. We say the United States because the United States is a corporation exclusively in the District of Columbia. That's where it's at. These arguments are cobbled together with constitutional law from the Uniform Commercial Code, Bible verses, and are used to avoid legal liability and criminal process. Look at this. Look at it. But they don't tell him he's wrong. With case citations, you're just calling him names. That's what you're doing. You need to go in. You got to listen when you make an argument for court or whatever, and you're citing your points of authorities. They have to go in and read your points of authorities. All right, to see if you are correct. They're not. Now, I'm not sure if he made this argument. Now, he probably didn't. Maybe he didn't argue his case right. I don't know. Maybe he did. Maybe he had a great brief or what. I don't know. Maybe I don't know. But this is what they'll do. This is what they'll do. Let me see. Denying a sovereign citizen Section 1983 claim against law enforcement. I don't know why they denied it. Because you can sue the police on the 40. I know I sued them. But anyway, these teachings have never worked in a court of law, not a single time. That is a lie. That is 100% a lie. Because I just showed you a case from over 125 years ago where it's worked. So they lying. But I'm not surprised by that because they're attorneys. And that's what they do. Doesn't surprise me at all. I saw that, cowboy. You scared my horse. SG, you funny, SG. You funny, man. Let me see. Posting stuff like this. Like, I'm not gonna. This is the only time that I will address stuff like that. I'm not gonna type, memorandum of law on this. Are you crazy? I'm not doing that. What you can do, if you watch this video, Black Prince, what you should do, if you're serious, and if you 100% believe that you're right and I'm wrong, I'll give you an opportunity to come in and we can discuss this on the air. All right. We can do that live, for everybody to see. I'm not finna argue back with you in the comments. Anyway, what else we got? Let me go back to the comment section, see what else. There might have been something else that I wanted to talk about. But let me elaborate on Carl Miller. I don't know Carl Miller. Never met him. He was probably deceased when I found this information about him. I'm not really sure if he was or not, but he knows what he's talking about. He is not wrong. There is a distinction between driving and traveling on the public highways. One is a privilege, the other one is a right. They cannot tax you for using the public highways because using the public highways is a right, but they can tax occupations that are engaged in business on the public highways, such as a truck driver, taxi driver, Uber driver, Lyft driver, cab driver, stuff like that. They can do that. But that is not a license. It's not a license to use the streets. It's an occupation license. Let me see. What is this? Oh, okay. And I think that might be it. I went live at about 6. Let me go to the chat, see if anybody got something they want to talk about. The problem comes from calling it right to travel. That alludes to the 14th Amendment, which has nothing to do with the driver's license issue. I think, believe it or not, even though that they're hiding, they're hiding it. I think all of the statutes in regards to driver's license and insurance and stuff like that. I don't think these are so-called constitutional statutes. I don't. I think well, let me phrase that. I know that these administrative agencies are unlawfully enforcing the statutes beyond the scope in which they beyond the scope in which they are beyond the scope in which they can be enforced is what I'm trying to say. One more team. Okay. If you receive a citation for speeding in your car, how do you fight it in court? Tell me you weren't driving, or are there any cases showing somebody won in court by claiming he wasn't driving? You're not going to find that on the public. I'm not sure how long have you been reading. I'm not sure how long have you been watching this live. You got to go and read old cases, one. That's what you got to do. All right, but look here. Even if there were no statutes or ordinances in regards to, speeding or whatever like that, you're still required to use it in a reasonable. Let me show you what I'm talking about, man. Let me show y'all what I'm talking about. Where is it at? Let me show you what I'm talking about. Right here. I think this is the principle right here. It just popped right on up. Okay, so this is on page 70. Before I get to page 70, I want to show y'all what this is. All right. A treatise on suits and chancery. This is equity. All right. This is equity. So what I'm trying to get people to what I'm trying to get you to understand, Juan, even if there were no statutes requiring you to use all of your property in a reasonably safe manner, you are still required to do that. Equity demands that you do that. So let's go here. And I'm going to read something to you. You got to study, one. You got to study. Right here. So use your own as not to injure. Let me see. So use your own as not to injure another. All right. While this is a law maxim, meaning a common law maxim, it is often applied in equity. The Chancery Court frequently enforces this maxim by enjoining the erection or commission of nuances to the complainant on the land of the defendant, because although a man may own the land, he has no right to so use it as to prevent his neighbors from enjoying their land. A man may be driven from his home by bad smells, noxious vapors, unbearable noise, shocking spectacles, and other intolerable nuances upon his neighbor's land, quite as effectually as though driven away by physical force. A man cannot so divert a stream of his own land as to turn water injuriously upon a neighbor's land, and he cannot dig so near the land of his neighbor as to cause the latter's land to cave in, or so near as to endanger his neighbor's wall. He cannot pollute a stream that flows through his neighbor's land, nor can he so stop or change the current of a stream as to prevent its ordinary flow through the land of another. A creditor, having his choice of two funds, ought to exercise his right of collection in such a manner as not to injure other creditors. Let me read this for you again. A driver, I gotta find a way to read it. Give me a second. We're gonna say I don't really want to say a driver because I know what a driver is. So we're gonna say a traveler. Let me see. Ought to exercise his right of locomotion in such a manner as not to injure others engaged in locomotion or something like that. Does that make sense to you? Equity demands that you do that. Anyway, a creditor having his choice of two funds ought to exercise his right of collection in such a manner as not to injure other creditors who can resort to only one of these funds. And it may be laid down as a general rule that no one can so exercise a right as to impair the right of another. You can't do that, especially if the latter right is of equal dignity in the sight of the law. The right of life, liberty, and property, and the pursuit of happiness must all be so used and exercised as not to impair or injure the equal enjoyment of these rights by another. You still have to do it if there's no statute for that. And if you don't, you're going to get in trouble. Because like I just told you, you can file lawsuits without statutes. You can lay criminal charges without statutes. You can be sent to jail without statutes. Statutes are not laws. They are a form of law, like rules. Rules are a form of law. So let me show you what I'm talking about. The federal rules of civil procedure. Those rules are not law. All right. They're not law, but they do have the force and effect of law if you voluntarily file a lawsuit in one of these federal courts. Once you do that, then these rules, you are bound to these rules. You are held to these rules. A statute is not law. If statutes were laws, then they would be applicable outside of their corporate territorial jurisdiction. They are not. An ordinance is not law. It's a bylaw. A statute is a bylaw because they're corporations. A police officer cannot act in his capacity as a police officer if he arrests you outside the corporate territorial jurisdiction of his municipality in which he is employed. Guess what he is? If he's no longer a police officer, guess what he is? Guess what authority he is acting under? He's acting under the authority of the common law. He's perfecting a citizen's arrest. Anybody can do a citizen's arrest. Anybody. At any time, just so long as they have probable cause for it. So, see, I'm the only SG on this page that I know. I'm not sure if you mean here on other SG got you. Must be another SG. I pop up on high frequency radio from time to time in some auditor's channel, mainly here though. Okay. If you're still watching, does that explanation of equity, does that make sense for you? You always have to act reasonably, responsibly. Doesn't matter if there's a statute requiring you to do that or not. You have to do that. Everybody has to do that. You will be, if you damage anybody's property, you can be sued without a statute. You can invoke a court's jurisdiction without a statute. Because statutes are not laws. Let me rephrase, it's not the law. Statutes under how this system is set up is derived from the common law. They were brought into, I'm not even sure if I said that right, but Statutes are inferior to the common law. Put it like that. Put it like that. But within their corporate territorial jurisdiction, even though they're not laws, they do have the force and effect of law. Let me see. Right here. Okay. The Chancery Court will, on due application, enjoin the defendant from so using his property or so exercising a right as to injure the property or rights of another. So let's say that there are no statutes at all whatsoever, but you, time after time again, you're not acting reasonably, you're not acting responsibly, you're damaging people's property by operating. We're going to say right now, but not operating. We're going to say by traveling in your own private conveyance. Let's say that you have received numerous warnings for this. Numerous. What would be a remedy to stop you from doing it again from somebody to somebody else? Somebody would petition, they would file a bill in equity to enjoin you from so using your property or exercising your right as to injure the property or rights of somebody else. That's what they're going to do. So they might say that you can't use your property here or there or something like that. You know what I'm saying? Maybe for indefinitely or maybe for a period of time. So I'm just giving you some reasonable conclusions based on how equity works. That's what I'm saying. This is what y'all need to study. This is the people's law. This is the law that is bound that binds the people. Equity. You are controlled by equity and common law. That's it. Unless you voluntarily make yourself subject to that other jurisdiction. All right. Let me see. I've read appeal cases of people claiming constitutional right to travel and right to drive. They lose every time. They never had the case law to prove their argument. Yeah, they're going to lose every time. They're going to lose every time. I wouldn't even argue this. Man, it depends. I probably would. I don't know. It just depends. Oh, my bad. They went based on what they heard and obviously didn't research for themselves. I agree with that, SG, because you got to research this stuff, man. You got to research. But I guarantee you, if they get somebody in there who knows what they talking about, they not finna adjudicate that. I don't think that they would find them. I don't think that they would find them guilty either, to the extent that they would make them pay the fee or something like that. He says, but it doesn't seem like the court cares what you or I think when it comes to traffic law. That you are absolutely right, one. Today they don't care, and I agree with you on that. Today they do not care, but I promise you, if you go and read the old cases, they laid it all out for you in the old cases. The judiciary back then, they did their job. I really think that back then they had a free and independent judiciary. They don't have one now. I'm telling you what I know for a fact right now. They don't have it right now. They don't. But back then, yes, they did. Yes, they did. If you don't mind me asking, where are you from? Like, what so-called state are you in, one? And I'm gonna show you some stuff. I'm gonna give you some game. Try to help you out. What state are you in? You research. Okay, so you saying you use these arguments, SG, and 4 of them were dismissed. 4 out of 4 of them was dismissed out of court, never made it in front of a judge. Is that what you're saying? So-called judge, anyway. Is that what you're saying, SG? Okay, you're in California. Okay. All right, give me a second one. Let me show you something. All right. All right, one. You said you're in California. All right. I'm going to give you some game. This website right here, case.law. If you want to find out what happened, you need to go and read old cases. All right. Because they're going to tell you, you're going to read old case. You'll read cases so old that they're going to tell you, like, for example, they may have cases in California that like before the city of Los Angeles became a municipal corporation. So in other words, before the people who owned the land then in Los Angeles voluntarily made themselves subject to the corporate territorial jurisdiction of the legislature. They might have cases that relate to that, because anything outside of the corporate territorial jurisdiction of the legislature, they do not have any authority over it, period. Statutes do not apply there at all. They don't apply there at all. At all. Inside the corporate territorial jurisdiction of the legislature is the democracy. That's the democracy. Outside of that is the republic. I literally have cases on my computer prior to these municipal corporations, these people back then forming these municipal corporations. They had a right to form these municipal corporations back then because they owned the land. It's their land. The legislature could not come in and take their land and form these municipal corporations. They literally had to have permission to do that by the people who own the land. I got cases on that. They're old cases though. But anyway, so when you go on here, go to old.case.law. When you hover over these so-called states right here, you click on it, it's going to go straight to the case, to the authorities. So you're in California. So we're going to click on California. All right. So there's a long list of cases in California. Let's see how far they go back in California. So it looks like 1855, 54. Looks like the oldest case is from like right here, 1803 to 2006. So these are the cases that I would read from time to time. All right. You don't have to read all of them because these are a lot of cases. This is just one volume, and there's probably 100 cases in this volume. So you click on volume 1, and all of the cases will pop up from 1803. All right. So, well, they got 1850 here. Now I don't see any 1803 cases in this one. So they must have misquoted that. But anyway, look at all these cases. These are just so many cases. So many. I'm not finna, I can't read all. This is just one volume. Let me just randomly click on something and see what we get. This is where they get a lot of their principles from. I'm letting you know that right now. This is where the legislatures back then, they were not that bright. They were not that bright. The judiciary back then, they were extremely intelligent men. And I believe that majority of the time that they got their cases right. They got their issues right. They did the right thing. Let's see. Let me go back. Let me see. This is just an example, all right? So when you click on a case, let's say you click on a case that you want to read or whatever, you find or whatever. Let's Bernard versus Mullen. We're gonna click on that. You want to read this case. You click here, PDF file. You click on PDF file, and a PDF file of this case will pop up. This is an actual book from the case, but they took pictures of it so you can read it. This is the type of stuff you need to read, man. You would be, man, look, if you go back and read these, I found cases about like family support cases that would just blow your mind away. Just blow it, just slap away. Let me close this. The Maximum Equity right here, boy. This is a good book. This is a very good book on equity. It's a treatise on equity by Henry Gibson, by the way. Let me go back here. I know exactly what you mean, Juan. I know exactly what you mean. But let me show you how to use that site, though, that I was just on. Let me show you how to use it, because there's a way that you can use it. So I tell you what. Give me something that you're interested in learning about, one. Type it in the chat. And then I'm going to search for it right now live to show you how it works. Man. Whew. Let me see. SG. Let me see what SG done Quixote abatement. Wow. Sorry to hear that one more time. Yeah. Oh, 4 for 4. You said you 4 for 4? That's what's up, SG done Quixote abatement. Yeah. Yeah, man. Let me see. Sheriff Deputy got me in a different county a few weeks ago. I'll see how they act. He seemed to know what I was talking about, though, and kept calling it my belief. Yeah, whatever. Thank you. I have a lot of reading. Damn, I imagine, man. Let me see. I explicitly rebut any presumption of using the public road as a place of business, as well as the burden of proof is on the prosecutor, which they don't have. Yeah, it's on the prosecutor. Can't use it as a place of business. You can use it for your private business, like you can use, like, let's say you work in the city somewhere. You know what I'm saying? And you want to use your private car or whatever you want to call it to transport your stuff from one place to your business. You can do that because you're not getting paid to do that. You can do that, but you can't. But if somebody's paying you to do it, if you're doing it for somebody else, no, they can tax that because you're working on there, and your occupation is like a delivery driver or something like that. That's what your occupation is. So they have to tax you for that. Man, so I ain't never. You know what, SG? What you need to do? You need to sue them so they'll leave you alone, SG. That's what you need to do. When you get some time, you need to contact me about suing them, because you can sue them for that, fam. They dismissed the case. They arrested you. They caused you an injury. You need to sue them. I guarantee you, if you sue them, they won't do it no more. Sorry, I gotta go. Company just showed up. Don't worry. It's not. He says, don't worry, it's not the police. All right, peace, one. Peace. It's an unstated presumption that you are operating in commerce, and people don't rebut that. That's the problem. Yeah, you are absolutely right, SG. You are absolutely right. It's a presumption. That's exactly what it is. You said you were never arrested? All right, now, SG, I'm finna fuss at you now. I got to get on you. I got to get on you. Matter of fact, let me pull up my book. I'm finna fuss at you now. You saying you won the arrest. I don't know why you say that, SG. I got to get on you now, SG. This is my ebook that I did for the DC circuit. Let me see. All right, SG. I got to get on you now. I got to get on you. All right, you said you were detained. You were not arrested. Okay. An arrest occurs when one's freedom of movement has been restricted. In other words, whenever you reasonably believe you are not free to leave, you are arrested. This includes traffic stops also. Anytime, and I mean any time, you reasonably believe, based on the facts and circumstances in your case, that you are not free to leave, then as a matter of law, you are arrested. I don't care if you're in your house eating a bowl of cornflakes and you walking around watching TV and everything, but you have police in here and they saying you can go, you can do whatever you want in your house, but you can't leave this house when you want to. If they say you can't leave that house when you want to, based on that fact that they said that, you can reasonably conclude that you're not free to leave. And since you're not free to leave, you are arrested. Exactly. he said, don't get the belt. My bad, man. I got to get on you now. Got insurance, so they can't tow. Cool. That's cool. This is what they call it, SG. When I found this out, it was just so funny to me. This is what they call it. Let's see. When detained for custodial interrogation, let me go with what they call it is a non-custodial arrest, despite the fact that they have you in custody. It's a non-custodial arrest. That's what they call it. Let me see if I can find something on it. Non-custodial arrest is defined as let's see. Here's one. A non-custodial interrogation becomes custodial when there is a formal arrest or restraint of freedom of movement, similar to that of a formal arrest, blah, blah, blah. Let's go here. Right here. I think this one good right here. I'm going to go and read this case, SG. Let's see. I got to get off here in a minute, y'all. I'm tired. I'm getting a headache. I ain't never. Let's see. Let me use this. Good God, they used the word arrest in here 207 times. Golly. All right, let me see if I can find it. Okay, here we go, right here, SG. I found it. All right, SG. Need some game, fam. Custodial versus non-custodial arrest. The word arrest may refer to either a custodial arrest or a non-custodial arrest. A distinction may be drawn between custodial arrests, which are made for the purpose of taking a person to the station house for booking procedures and the filing of criminal charges, and non-custodial arrests, which involve only temporary detention for the purposes of issuing a summons. The police may conduct a full search only when incident to a lawful custodial arrest. Let's see. People blah, 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 stating that the distinction in Robinson between custodial arrest and arrest followed by release at the scene is important in terms of the incidental search, blah, blah, blah. Yada, yada, yada. This might be a good case to read right here. If you want, if you want the case citation, let me know and I'll give it to you so you can read. So you can get the principles out of it. If you want it, SG, just let me know. Yeah, that's why they call it house arrest. That's exactly right. Yeah. I bought a copy of the Corpus Juris Secundum Pleadings book to learn to write a counterclaim. I'll file that with the abatement, get their claim dismissed, and win mine at the same time. Yeah. Now you need to sue them under 42 Section 1983. That's what I do. I promise you, you file one lawsuit against them, one, and they gonna put you on that do not detain. They probably already got you on the list, to be honest with you. But, you want to be compensated for your time. So I would sue them for that if I was you. They dismissed the case against you. That's what I would do. Yep, that's what I do, man. I'm going to give you the case citation, too, if anybody wants it. That's the case citation to this case right here regarding custodial versus none. Matter of fact, let me just post this right here right now. Let me go and post that so y'all can have it on the channel. Post that for y'all right now. Let me give y'all the case citation just so y'all can have. There we go. All right, y'all. Before I leave, I want to say rest in peace to Carl Miller, and thank you, Carl Miller, for that 5 hours of your time. Probably took you longer than 5 hours, and there's no telling how many hours you spent in the law library. I don't even think they had computers back then when he made this video. I'm sorry, not when he made this video, but when he was studying in the law library. They probably didn't even have computers then. But I just want to thank him for all of his research. May he rest in peace. And his argument, his right to travel argument, or whatever you want to call it, it does work. It works for me. I sent notice to DMV and got a response from the Attorney General office when I got the car 2 years ago. So the state has been noticed. Notice to principal is notice to agent. Boy, you cold, SG. You might need to start your own YouTube channel. You cold, boy. You cold. I don't know when he passed. I do know that they say Carl Miller passed. I think maybe 2019, not 19, but 2009 or something like that. I don't really know, to be honest with you. I don't even know if he is, but based on that video, that video, I think that was probably recorded in the 90s, and he looked pretty old in that video. No disrespect to him, but he's probably transitioned from this world. I would be surprised if he isn't. But if he isn't, I don't mean no disrespect, so I kind of want to be respectful. But I believe that he has transitioned from this world. I don't know for certain though. Okay, y'all, I'm gonna get on up out of here because I'm tired. Let me see. Nice job, yes, respect. SG said he 4 for 4. He 4-0. He undisputed on the traffic in traffic court. He ain't lying. It's a presumption that you're using the roads as a place of business. It's a presumption. And you got to rebut that presumption. The reason why it's a presumption is because I'm of the opinion that when they give you this traffic ticket, it has a plethora of legal conclusions in it without any facts to substantiate how they came to the conclusion that you're a driver and that you were operating a vehicle, motor vehicle, or other vehicle. You know that feeling of helplessness you might have as a black person in America. I don't know. What you mean, SG? I'm a little lost. I forgot what we were talking about. You can if you got a local law library by you, SG, you can go and get you a pleadings and practice book from the local law library. Because generally speaking, almost all this stuff it pretty much is the same for real. Y'all hit that like button for me if y'all don't mind. I would really appreciate it. The more I learn about law, the more that goes away. Oh, okay. Oh, you asking a question? Okay. My apologies. Yeah, I know what you mean. But this goes for anybody though. Once you know what your rights are, it's a wrap. They're gonna leave you alone. They're gonna be very, very careful how they deal with you when they know you know how to cost them money and you know your rights. I've been stopped numerous times over the past with 8 active capias warrants, and I was let go almost every single time until I got on the internet and started telling people that they had a right to defend themselves against police in self-defense. I made that comment on a local page, on a local news page or something like that. And they must have pissed them off, so they must have took me off the list or something. Because I got arrested probably 3 or 4 years ago, something like that. But now I'm cold. I'm pretty ready to file another lawsuit because I got some cases dismissed against me in 2022. I got some cases dismissed me, so I'm finna file some federal lawsuits on them. Matter of fact, it's gonna be this month. What? Let me see. I finally found a community college with am.juris and corpus juris secundum. That's crazy. That's good right there, SG. I found pleadings book on. Let me see what you're talking about. I might need to go on there too, SG. Let me see. What he said? I think he said Amazon, didn't he? Let me see. No, he said eBay. Okay, eBay. It might be. Let me see if they got one on Amazon. Pleadings in practice. Pleadings in practice. What is this? I don't know what none of this is. You know what? Let me copy and paste this. Got my PO box on here. Google. These books so expensive, man. Look at this, man. Let me show y'all something, man. This stuff is so expensive. American Jurisprudence, Pleadings and Practice Forms, annotated. A monthly plan is like $3,000. Look at this. This edition only. Let's see what's in here. Individual volumes. This is a lot. One of these books is like $3,000, y'all. This is just crazy. Let me see if I can find out. I can get a little PDF summary of the contents. Let's see, American jurisprudence got 47 pages, pleasing practice forms annotated, abandoned property, lost and unclaimed property, abatement and stay, general consent. Let's see. They might have some forms in here. Let's see what we got. I ain't never represent, baby. Oh, they ain't even got the forms in here. But sometimes you can go on here and they'll have some they'll have some good stuff on here. Let's see. Westlaw, Texas jurisprudence, pleadings and practice forms. Summary, contents. Oh no, I want to get a preview of the book. No, that ain't it either. They normally give you like a preview of the book so you can see. Trying to see if they're gonna give me like let me preview the book, because they normally let you preview it. Hope they gonna let you do it on here though. Nah. Anyway, all right, y'all. I'm tired. Got a headache. An hour away. Yeah, that's kind of far. That's probably like 50, 60 miles. 2 hour round trip, so that's far. All right, y'all. Before I leave, any questions, anything like that? Because I'm about to go. I'm tired. I haven't been on here lately because I've been litigating cases. So I'm not finished. I got to finish these briefs. Any more questions before I go? I think I'm getting a cold or something, man. If not, we'll get on up out of here. Gotta set up this ebook. All right, y'all. Well, I'm gonna get on up out of here. Hope everybody enjoyed their Friday and their weekend. Good night. Peace, y'all.